And a very good morning to you. It's John Fradgley from the Bell Legal Group, back with you for another program of The Law and You, which means it's Tuesday. Your opportunity to get free legal advice between now and 9:30. That's 10:30 Tweed Coast time. All you need to do is get on that telephone, 55208888. The number again, 55208888. Don't forget, we do have an email address that you can send questions to if you're not in a position to get to the phone, but we won't be able to answer any email questions until next week because we simply can't read them and then deal with them on air while we've got calls coming in. So the email address is talkback@4crb.com. That's talkback@4crb.com. But in the meantime, our phone lines are open. There's no callers there at the moment, so you could be our very first caller for the morning. 55208888, and of course 07 in front of that if you live south of the Tweed River. Thank you to my colleague Dan O'Connor, who was here with me in the studios last week, and we had quite an interesting discussion between calls on the vexed question of blended families and how to deal with blended families and second marriages in terms of your estate planning. I suppose last week's program is a very good segue into what I thought I'd talk about today while we're waiting for some calls to come through. And that, of course, is the question of the importance of having in place your Advance Health Directive, enduring power of attorney, and your will. These are obviously uncertain times. Many people are very concerned for their health. And one of the things that you really should be doing whilst you're fit and well is getting in place or updating those documents if you haven't looked at them for a while. So dealing firstly with the Advance Health Directive, that is a document which you're able to complete with your GP. And basically it is a directive to the health authorities and also to your family as to what you want done in certain situations. So, for example, if you were to be in a road accident and you're in a coma in hospital on life support, and your wishes are that you should not, if the only way that your life can be maintained is by life support, then you can express the desire that you're not given life support, and basically you wish nature to take its course so that if you can survive naturally without intervention, then that's fine. But if life support is the only way of keeping you alive, then you would rather not have that treatment. There are other instances where people do need an Advanced Health Directive or do find reason to put one in place. And a very good example of that, of course, would be for people of the Jehovah's Witness faith. For example, many of you are probably aware that people of the Jehovah's Witness faith do not believe in receiving blood transfusions in the event of serious illness. And obviously an Advanced Health Directive, in my opinion, would be an important document for them to have in place so that there is quite a clear reference to that, so that both family, friends and health authorities are aware that that they are your wishes. Moving on from that, of course, we have the enduring power of attorney, and it's a little bit different from state to state. So in Queensland, we have one document, which is there are two forms of the same document. One is a short form, enduring power of attorney, and the other is a long form, power of attorney. Now, the difference between the two is that the short form is used when you're going to appoint the same person to act as your attorney for personal and health matters and also for financial matters. But if you want different people to take on those roles, then you would use the long form of the power of attorney, because that document allows for the appointment of one attorney or a couple of attorneys for personal and health decisions, and it may provide, for example, for your accountant or someone who has control of your financial affairs to be the person who will make your financial decisions, and that can often be in conjunction with someone that you've chosen to assist them, say a trusted member of the family. So a very common situation with enduring powers of attorney would be, and I have to say that the overwhelming majority of powers of attorney that we prepare are in fact in the short form, so people appoint the same persons for personal health matters as well as for financial. But just in an average family situation, and putting aside for a moment blended families, it would be quite common for a husband and wife to appoint each other as attorneys in the first instance, but then if the appointed attorney is unable or unwilling to act, then it may be that they appoint one or more of their children to act in that role. And ideally, I would say that if you are able in the second instance to appoint more than one attorney, and the absolute ideal is if you have 3 people available with provision for any 2 to sign, well, that is certainly good, because in that important situation where your spouse is no longer acting as your attorney, it's nice just to have a little bit of checks and balances there, so that one of your children, for example, may not be tempted to borrow a little bit of money out of your bank account if they're in a bit of a desperate financial position. And of course, having a situation where 2 people have to sign just reduces the risk of something untoward happening. And over the years, although I have seen very few situations where powers of attorney have been abused, and when I say that, I'm talking about probably only 3 or 4 instances over my career that I'm aware of, so that's over a 40-year period. Nonetheless, one instance of a power of attorney being abused is one too many, and in all of those cases where the powers of attorney were misused, it was where there had only been one alternate attorney appointed. So for that reason, it just does underscore the very, very significant reason why it is best to have a couple of alternate attorneys if your spouse for any reason is not able to act for you. We're going to take a word from our sponsor, and we'll be back after that with more of The Law and You.
If I asked you, do you want to move into a nursing home? I bet the answer would be no. And that's fair enough, we've all heard the stories. But what if we turned aged care on its head? Imagine a place that gives the power back to the resident. You'd have your own apartment, your own furniture, you'd bring your pet, you'd be cared for, and you'd call the shots. Well, Odyssey Private Aged Care is exactly that, plus loads more. I'm Phil, and I'm proud to say Odyssey is opening soon in Robina. Search Odyssey Robina online or phone 551 6720.
Another sponsor.
You're in tune with 4CRB 89.3 FM. The program is The Law and You. It's your opportunity to get free legal advice between now and 9:30. All we need you to do is get on that telephone as soon as you possibly can. Our number, of course, is 55208888. That number again, 55208888. Please don't leave those calls to the last 5 or 10 minutes of the program, where, as you know, we invariably get a bank up of calls, and not infrequently have to take some of those calls off air. So we would much rather deal with your calls on air right now. If you can call through 55208888. So I was talking then about enduring powers of attorney, and one thing that I should mention is that in New South Wales, which is part of our listening audience, the situation is different in that there are 2 documents in New South Wales that you need to complete in order to be fully covered for an enduring power of attorney. One of them is, in fact, a power of attorney document, which has provision in it that you can provide that it is an enduring power of attorney, which means that it will continue on even if you as the donor lose capacity, because the important thing and the important difference between a power of attorney generally and an enduring power of attorney is that, as the name suggests, if the donor, the person making the power of attorney, loses capacity, it continues to have force and effect. If you just have an old general power of attorney, that power of attorney automatically ceases when the donor of the power of attorney loses capacity. So if you'd made a power of attorney back in the 1970s, for example, and even up to or the late 70s, that power, and it was just a general power of attorney, then that power of attorney would not have any effect if you now lost capacity. So that's the reason why it's very important to check. In New South Wales, as I say, you have the general power of attorney, which it can also be completed so that it is an enduring power of attorney. But separately, to look after your personal and health matters, you must do a separate document which is called enduring guardianship. So, as I said before, in Queensland we have the one document which covers both areas, the personal and health attorney as well as the financial attorney. In New South Wales you need two separate ones. The enduring power of attorney will act in relation to your financial matters, and the enduring guardian will act in relation to your health and personal matters. Now, the other thing too, in relation to enduring powers of attorney, which is becoming increasingly important with the increase in the complexity of people's affairs, is that you make provision, you may need to consider making provision in your enduring power of attorney for people to enter into conflict transactions. And this would be very, very common for a husband and wife to allow for conflict transactions. So that might be, for example, if for some reason the bulk of the funds in a couple have are in the bank account of the donor, or if funds are split across two separate accounts, one for the donor and one for the spouse who's the attorney, then the spouse can't simply take money out of the donor's account and use it for their own purposes, because technically that is a breach of the powers of attorney legislation unless the power of attorney provides for conflict transactions. So that is extremely important in that area of powers of attorney, and that's why now I believe it very important that you complete your power of attorney with your lawyer rather than simply buy the form and complete it in that way. But enough of that. We've got our first caller online. As we say, a very good morning to Rhonda. G'day, Rhonda. How are you today?
Yes, good morning, John. Thank you. Good. Just a quick one.
Sure.
With regard to my sister, who is, she has a heart condition and it's deteriorating. She's had a pretty good run with a pacemaker and defibrillator. But the point is that with regards to the enduring power of attorney, which would fall to her son, she only has one child, no partner, and no husband, and divorced, and myself. And so the question is really that she doesn't own a car, a property, has no cash flow in the bank, and is living on the disability pension.
Right.
Well, should she? We've got the health directive about to make the options accordingly.
Yep.
To take that pressure off. But with regards to somebody who's in that position, is it what would happen if whatever she's got, her personal possessions and things, does she still have to go through formalities and things, I guess?
Does she have a will?
Yes, she does.
Okay, well, as long as she's got a will, then that's okay, because the power of attorney and the Advanced Health Directive are only effective while a person is alive. And once they pass away, those documents automatically cease to have any application.
Impact.
So that's very important, and the will then is the document that will take over. And in her situation where she doesn't own a home, did you say?
No, has no assets whatsoever other than personal, furniture and clothing.
Right.
And no cash flow.
A little bit of money in the bank?
No.
All right.
She lives
okay, well, in that
my
situation...
nephew subsidises her electricity bills and things like that.
Right, okay. Well, in those circumstances then, really, if she's got a will, if there is anything unusual that crops up after her passing, as long as she's got a will in place, that would certainly deal with it. And there certainly wouldn't be any need for probate of the will or anything like that, because from what you're saying, it doesn't sound like she has assets sufficient as would warrant an application for probate.
Yeah, right. And with regards to his accessing her things, like you were saying about the bank accounts and all those sorts of things, I mean, just to tidy things up and stop getting mail and all that stuff, he'll have automatic, what's the legal, should she have passed today and tomorrow, what's the first step?
Well, he would be the executor, so under the will he's entitled to deal with all of those issues.
Yes, I think.
But his right to do that would be as executor under the will after she passes away, not as enduring power of attorney.
Right, and just a quick thing with regards to him. He's 37, and I'm trying to encourage him, as you said, if you're in a car accident and in a coma, he does have the opposite. He has a property, cars, and, money in the bank. So I'm trying to convince a 37-year-old that, stop and smell not the roses, whatever the opposite to that is.
Yes, well, to just take a responsible look, particularly in these current times, I certainly think it would be very advisable, Rhonda.
Yeah. Is it possible for you at some point to maybe say something along these lines in one of your shows, addressing young people?
Yes. Well,
I'd appreciate that.
I certainly was.
Then I'll record
my comments this
say
morning to that subject, but I didn't specifically mention young people.
Yeah.
But
I think if you did that sometime down the track,
it
I
is
can
far more
record
important in some respects for the young than for the elderly.
Absolutely.
All
All
right.
right.
Okay,
Thank
Rhonda,
you so much.
Thanks for your call. Time on 4CRB is just coming up to 21 and a half minutes past 9, past 10 on the tweet as we say good morning to Bill. G'day, Bill. How are you? Hey, Bill, are you there?
Yes, John.
How can I help you today?
Person that is a paid carer
Yes.
is required to cease being a power of attorney.
Yes.
But
Well,
what
they
is the
can't
definition?
be a power of attorney if you're a paid carer.
What is the precise definition of a paid carer?
Right. Well, a paid carer would be someone who is employed by a caring service who comes in to your home and provides caring services for you. So you're paying to have those services provided. It certainly doesn't apply to someone in your household who's on a carer's pension. For example, if you have a son or daughter who's living with you and they're receiving, or a spouse who's receiving a carer's allowance, that doesn't apply in that situation.
But if the parent paid a son to provide services, does that constitute a paid carer?
I don't know that it does apply in that situation, but Bill, leave that with me and I'll just check on it and I'll comment on it next week if that's okay.
Yeah, sure.
Yeah, because I know in situations, for example, where family members are receiving a carer's allowance, that it doesn't apply. And before I make a definitive comment on it, my immediate reaction is that it doesn't apply, but before I make a definitive answer on it, I'll check on it and I'll comment next week.
Right, thanks very much, John. Appreciate that.
Okay, no trouble at all. And the time on 4CRB continues to roll along. It's 23 and a half minutes past 9, past 10 on the tweed, as we say a very good morning to Ian. G'day, Ian. How are you today?
Yes, good morning, John. I'm very well, thank you. I'm an avid listener to 4CRB. Love the programs.
Well, thank you for that.
Throughout. No problem. I've been listening with interest regarding the enduring power of attorney, the difference between Queensland and New South Wales.
Yes.
We are the Commonwealth of Australia.
Yes.
Why don't we have standard rules so everybody knows the rules and regulations? And
well, I must say that I'm increasingly coming to that view, that it's crazy. For example, I can't understand why we don't have a national driver's licence.
Exactly.
Why we don't have so many of these things that apply at a national level.
We have the one currency.
Yes, well, that's exactly right, and of course that's controlled by the Commonwealth. But the unfortunate thing is the states are very reluctant to give up their laws, and I did mention Queensland and New South Wales, the difference in powers of attorney. I hate to tell you this, but it's different in every state. So there are no two states in Australia that have the same system.
Maybe, the states are not giving up their individual powers, but surely we can start to standardise so people know that it's going to be exactly the same. I'm down at Tweed, almost border issues, and it's got it's put so much more difficulty into, especially the elderly people. They don't know what legislation may be coming on. I'm a JP, and I'm only licensed, only accredited in New South Wales to do JP services. But to me, it's about time we started to go Commonwealth. We are one nation.
Yeah. Well, I think this has really been underlined by the approach in relation to the coronavirus, hasn't it? Because, we've got, conflict between the states, or not conflict, but difference of opinion in relation to should we close schools, should we not close schools,
and whatever.
The Commonwealth Health Officer is saying they should remain open. States have decided to go on their own. Therefore, we've got this confusion in the community in relation to it, which is certainly at the present time extremely unhelpful.
Exactly, and in the times of national crisis, what we need is some stability, some guidance, and some hope. Let's not keep spreading all the fear. Let's look at hope, and we'll come out the other end a better nation, hopefully.
Yes, well, I think, the difficulty for the Commonwealth Government at the present time is that with the National Cabinet, the Commonwealth Government has been endeavouring to take the lead in relation to this, and, it's not terribly helpful if state premiers are coming out and, sort of deciding on slight variations for whatever their reasons may be. Because from what I understand, just if you take the schools as an example, the health officers of all states, including the Commonwealth, are saying that schools should remain open. So it's a bit of a vexed question. But anyway, I don't think it's probably going to change in our lifetime, Ian, I'm afraid.
I don't think so, John. Unfortunately not, mate. But thank you for your time. I appreciate it. Thanks, mate.
No trouble at all. And the time on 4CRB is 27 minutes past 9. If you have a question or a query, please get back to it, get on the line as soon as you can, because we've only got a few minutes to go. 55208888. The number will be back after this word from our sponsor.
Are you looking for a new financial advisor? Would you like an advisor who won't let you down? Someone who has no connection with a bank or insurance company? Are you looking for a financial planning company that values long-term relationships, has decades of experience and prides itself on great ongoing service? If so, then look no further. Retirement Planning Partners would like to offer you a no-obligation meeting to see how we can help with your financial planning needs. Call us today on 5593 0005 or check out our range of financial planning services at rppartners.com.au. The number again is 5593 0005.
Retirement Planning Partners is a corporate authorised representative of Madison Financial Group. AFSL number 246679.
And this is the Law and You on 4CRB. Our telephone number 55208888. If you have a question or query, you'll need to get on that phone very quickly if you want it answered today. Otherwise, don't forget you'll be able to send in emails for next week's program at talkback@4crb.com. And Rhonda, of course, was mentioning earlier about the importance of wills and powers of attorney for young people, and certainly over the years I've seen instances where young people haven't bothered to make a will or a power of attorney, and some accident has occurred, and it certainly does create difficulties in both areas, because if you don't have a power of attorney, then someone has to make an application to the Adult Guardian's Office to be appointed the administrator of your financial affairs and your guardian for personal and health matters, and it is a cumbersome and slow process. The other one, of course, is wills, and all too often we see young people who are taken tragically in car accidents and other unfortunate things, and if they don't have a will, they're deemed to die intestate, which means that they've died without a will. And of course, the problem that this can create, and there was a case in relation to it not so long ago, where, for example, the child may be very close to for example, their mother. They've been living with their mother all their life. They've had nothing to do with the father. But if the father is on the birth certificate and the child dies intestate and has no children of their own, then mum and dad are going to be the ones who are going to be receiving the estate, and the son or daughter who passes away would be horrified if they knew that was going to happen. But enough of that. That's today's program. I'm John Fradgley from the Bell Legal Group. I look forward to being back with you again next week. But as always, until then, it's goodbye and God bless.